Ladies and gentlemen, our next speaker is John Mayhew from Atlanta. John is well known to most of you. He is one of the most accomplished domestic lawyers in the state of Georgia and indeed in the country. And John has written books on various aspects of family law. He's written numerous articles. He is he's a very frequent CLE speaker, and his accomplishments truly are too many to mention. He holds directorships in, or has in the past, of all of the leading organizations related to family law, including the American Academy of Matrimonial Lawyers. Since 1992, John has also chaired the Family Law Convocation on Professionalism. I asked John to speak on national trends in family law, and there's no one that is better qualified than he to do so. And while he has not yet appeared on the cover of Rolling Stone, I'm confident that one day he will.
Pervasive new avenues of speech and communication are causing family law practitioners to confront basic maxims of constitutional law, most notably the First Amendment. This confluence has dramatically changed the evidentiary analyses of our cases and contains dominant underlying themes of criminal and tort law. Far from the stark and, I would suggest to you, simple admonition to not yell fire in a crowded theater, we are now blogging and texting and emailing and using camera phones to rant and to criticize and to express the most base feelings about our spouses, our children, judges, lawyers, and perhaps life in general, and sharing the most lurid and intimate, perhaps deprecating details of our own existence with friends, with family, and with persons whom we will never know who have a prurient interest. These communications are now the epicenter of salient family conduct, from child rearing to sexual and cyber affairs to finances and to graphic and damning portrayals of the very character of litigants and witnesses in domestic relations cases. Please note from the materials, which I hope are a good resource but which we will largely ignore for the purposes of today, that legal commentators pose a singular threshold question regarding the illegal use and dissemination of email. That question is, was there a reasonable expectation of privacy by the sender or by the recipient? You may not download, you may not view, you may not copy, you may not share, you may not make any use of email to which you were not freely given access. I believe that's the consensus of legal commentators. In Georgia, under the case of Ransom versus Ransom, which dealt with tape recordings, you cannot use illegal evidence, which these wrongfully intercepted emails are, for any purpose whatsoever. We need to be clear about that. Any purpose whatsoever, which includes impeachment. It includes fashioning deposition questioning. It includes requests for production of documents. You can't send them to your experts. You can't share them with witnesses. You should not have them in your offices. Be careful. But there are vexing questions in other contexts beyond emails as to the extent to which we have vitiated reasonable expectations of privacy by our own conduct, by our participation in what I call the age of the Internet. I would suggest the term reasonable is a word that lawyers have sort of hijacked. It's hackneyed. It's largely ineffective. We use the term reasonable for a euphemism, for my point of view is the correct one. It's tendentious. It's biased. When an adversary tells me that they're going to make a reasonable proposal to me, I instinctively reach for my wallet and my car keys to make sure that they're secure. When the judge begins to make a reasonable pronouncement, I swallow hard. A late 19th century satirist defined reasonable as, quote, accessible to the infection of our own personal opinion, end quote. And so it is with privacy issues. I would posit to you that the concept of privacy is largely distinguished today by its diminishment. Historically, privacy meant secluded. It meant hidden. It meant not for public view or consideration. The ancient Greeks believed that privacy was the boundary that separated us from public life. The Hammurabi Code considered privacy of such importance that to enter a man's home, remember women didn't have homes then, but to enter a man's home without permission resulted in the death penalty by virtue of invasion of privacy. And yet the concept of privacy has been largely unrecognized in American jurisprudence until recently. The concept of privacy as something that would yield a remedy was not first made known to American lawyers until a Harvard Law Review article in 1890 by Judge Brandeis. Professor Prosser did not identify the four main tort-based privacy causes of action until 1960. We did not recognize a constitutional right to privacy by the United States Supreme Court until 1965, the case of Griswold versus Connecticut. So we have a new concept of privacy with technology that challenges the imagination in divorce cases. Nationwide, we are experiencing a revival or a rebirth of Professor Prosser's torts in divorce cases. Causes of action for property division and contempt now laced with public disclosure of private facts, false light invasion of privacy, appropriation of name and likeness, and defamation. And yet many commentators suggest today that the age of the internet has rendered the old privacy torts, since 1960, relatively meaningless. Why? The suggestion is made that it is because we are now all public figures, everyone in this room, and therefore your standing to assert a privacy cause of action is tenuous. Query: do you have a privacy right not to be photographed sitting in this seminar as you nod off in slumber? Is there a limit on the use I can make of that photograph, that image? Can I take that image and set it to music? Can I caption it regarding my thoughts regarding judges and family lawyers? Can I caption it with inflammatory and with very difficult and perhaps outrageous imagery? Use your imagination. Is there a remedy that you would possess for my distasteful use of that image? The answer is largely no. I can take it and put it on MySpace. Recently, a young woman who exposed herself at Mardi Gras was videotaped. That videotape was used to advertise pornographic movies to which she had no relationship. She decided to sue. And her fate in filing the cause of action for false light invasion of privacy was what? Summary judgment. Contrast that with a case where an ex-fiancé had a reasonable expectation of privacy regarding her treatment at an IVF clinic, despite the fact that she had used her ex-fiancé's credit card at the clinic without his permission. In the family law realm, ex-spouses are now blogging expressions of hatred for their exes, for their lawyers, for their judges, and for life in general.